SJC 12966, Daphne Moore, the Executive Office of the Trial Court Administration.
Thank you very much. Mr. Thompson.
Morning. Good morning, Chief Justice Bud and associate members of the court. I'm John Thompson, and with my partner Linda Thompson, we represent Daphne Moore, who's an assistant magistrate, clerk magistrate of the Hamden Superior Court. There's an urgency in this case that I want to express as simply and directly as I can. Ms. Moore has been driven into poverty in the middle of this COVID pandemic that we're dealing with now. This is the result of her having been suspended without pay from her position as an assistant clerk magistrate, and it has deprived her of, the suspension has deprived her of almost all of her income for the past 2 years. It's been 23 months. She's still employed by the trial court, but she has no income from that job, and although she's a licensed attorney, she's unable to practice law because of Canon 3. So she is trapped in what might be called the gilded cage of having a job with no income. Her livelihood has been taken away from her. And
is she able to do any work other than being an attorney? Would the canon permit her, or would the rules permit her to do any other kind of job?
The rules would permit her to do another kind of job, but she is a single mother and a single grandmother. She has 2 grandchildren, ages 12 and 7. And since 2015, she has been the guardian of those 2 children by order of the juvenile court. So she is responsible for her daughter, Nia Moore Bush's 2 children, and that really limits the work that she can do outside of working as an attorney. There's no work available to her that would come anywhere near compensating her in a way that would meet her financial needs.
Okay, now can I direct your attention to the statutes that you were referring to in your brief regarding discretion and the trial court administrator's discretion with regard to discipline? Can you explain that argument a little more?
Yes, Justice Seifer. It begins with the proposition that the court administrator's authority to suspend someone is given by the enabling statute is Chapter 211B, Section 9A12. That's the only source of that authority. And that statute says, notwithstanding any other general or special law to the contrary, when necessary for the proper administration of justice, the court administrator can suspend a trial court employee with or without pay.
Okay, and then you say that's the only source of authority. If that statute did not exist, could the trial court administrator not make disciplinary decisions?
I don't believe that the trial administrator could, and I believe that's why the legislature in Chapter 9A, in Chapter 211B, Section 9A12 specifically granted that authority.
Okay, and if we were back in the old days where we had no trial court administrator and the trial court was running as it used to, would the trial court not be able to institute discipline?
At the time that the trial court was administered by the Chief Justice of Administration, there was a similar statute. I don't know at what point in time 9A12 was instituted. It was called 9A20 back when it was under the CJAM. Before that, I suppose it might be that the court would draw on its inherent authority, which is described in the case of Wong versus Liu. And basically, functions under the same restraints. That is, the inherent authority of the court also calls for exercising authority when necessary for the proper or fair administration of justice.
So, and I just have one more question, and that is that your interpretation then of that statute is that the trial court administrator cannot exercise his or her discretion by instituting procedures or rules to apply based on objective criteria.
By objective criteria, I wouldn't say that an objective criteria that did not involve discretion would be acceptable under the statute or under the inherent authority of the court. That is,
So any decision regarding personnel has to be a discretionary call by the trial court administrator without a rule behind it.
no, I wouldn't say. I'm much more focused than that. I'm saying that any rule that deals with the suspension of a trial court employee, with or without pay, is necessarily discretionary. And because of the way the statutes are organized, that authority only exists as a result of 9A12.
And the only person within the system who could do that, the trial court administrator could not delegate that authority, I assume.
I don't know if he or she could, but even if it was delegated, it wouldn't change the nature of the authority. The authority is defined in the statute in a way that we argue makes it an inherently discretionary decision. And even when operating outside that framework, as in the Joseph cases, this court has followed the same kind of discretionary judgment, has used the same kind of discretionary judgment. It is, I think, when you look at the Joseph cases, they're very instructive because when that case began, when Judge Joseph was indicted for misconduct in her office, and I would note that that's a difference here, that is, Ms. Moore has been indicted, but not for misconduct in her office. It's the charges against her have nothing to do with her work as a clerk magistrate in the Superior Court. But when Judge Joseph was first indicted by the federal authorities, this court issued a one-sentence docket order.
Counsel, before you get into the Joseph cases or the Joseph case, explain to me why the court administrator is precluded from promulgating this bright line rule if he or she believes that once somebody is indicted, it is necessary to ensure the proper administration of justice to suspend them without pay. Why is that outside of the power delegated here to the CA?
Well, Justice Wendland, the power that is delegated is specifically articulated in the statute.
Right, and my question is, with regard to the statute, explain to me your position that if the CA has determined that it's necessary to ensure the proper administration of justice, to have a bright line rule that says, once somebody's been indicted, you don't get pay. Why is that outside of the scope of the statute?
Well, a bright line rule is a rule without discretion. I would take that as an agreed definition of a bright line rule. That is, it operates.
Except that the discretion was exercised ex ante. The court administrator has said ex ante, before anybody's before me, before anything happens, once somebody gets indicted, no pay. That's the discretion. They could have taken a different position.
Well, in other words, the court administrator has exercised his or her discretion to not exercise discretion.
Well, no, to choose in his discretion to choose this rule as opposed to any other rule, that's a discretionary exercise.
Well, the discretion to choose a rule is not the discretion that's granted in the statute. The discretion that's granted in the statute is subject to what's called the principle of necessity. That is, the phrase, when necessary for the proper administration of justice, is a phrase that has an inherent meaning. That is set out in the Wong versus Liu case, and when the court talks about its inherent discretion to discipline lawyers. The principle of necessity, according to this court, is a principle that requires the exercise of discretion and restraint on a case-by-case basis. That is, the decision whether this is an event that calls for discipline, whether the discipline involves suspension, and whether the suspension involves pay or no pay. Those are all choices. And under Massachusetts law, the granting of authority to exercise choice is necessarily a discretionary decision.
Well, I'm not sure that answers Justice Wedden's question, though, because we have to look at the legislative intent with the words proper administration of justice. And I don't know why, please let me understand why it wouldn't be a proper delegation to the court administrator within this statute to say, okay, it's just this exact question. All right, you decide whether for the proper administration of justice, whether or not you think if someone commits a felony, everyone, when that happens, that they are not going to receive pay during that period. Why isn't that a reasonable interpretation of the statute and therefore a reasonable delegation to the court administrator?
Well, it is not a discretionary decision. That is, the rule itself is, I would say, as this case discloses and as the Joseph cases disclose, unjust. That is, the decision here involves interests more than simply the interests of the trial court or a simple administrative convenience interests. Other interests are involved here, and that's what the statute recognizes. The proposal that this is a categorical decision, that is, you can justly conclude categorically without considering the circumstances of the case, of the interests of the court administration as a whole in this situation, and the interests of the individual, mark that as a discretionary decision. That is, the balancing of interests, the choosing of sanctions, the degree of the sanction and so forth, all speak to, and these are all expressed in the statute, speak to the need to make a balanced judgment that is that's determined to be just. That is, we're dealing in the administration of an agency that has as its fundamental business the delivery of justice. That is, of the balancing of interests in any kind of a situation where there's a conflict or a dispute or a decision to be made, the balancing of interest in light of principles and values that drive the operation of the organization and that produce what is determined to be, by process, to be a just outcome.
But if the legislature,
Sorry.
please.
Are you making a due process argument now, or is this the ultra vires argument? I'm confused.
Well, it is, those are different arguments that have the same focus. That is, it's not possible, for example, the due process argument fundamentally is this statute creates a right in the employee not to be suspended when it is not when it's not necessary for the proper administration of justice. The term necessary is a term that is relative and conditional, that is, depending on the circumstances. A bright line rule like this is going to lead to a suspension without pay, no matter whether it's necessary or not. When the language of the statute, when, means not always, that is, when is a specific set of circumstances, a specific occurrence, when necessary. Necessary is not an absolute term. It's if the phrase when necessary means that it's not always necessary. If you have a rule that imposes that penalty, and it is a penalty, as the court said in Joseph, it's a harsh sanction stripping someone of a paycheck. When it's not necessary, it's a violation of due process to take that person's livelihood away from them. And when you do it categorically, you're sometimes going to do it when it's not necessary.
Now, counsel, your client had a hearing, did she not?
In formal terms, yes, she did, Justice Seifer.
But you're claiming it's inadequate?
It is inadequate, and for this reason. The only thing, because of the operation of Rule 16600B, the only relevant question was she indicted for a felony?
Okay, let me ask you a different question then. I understand that. Going to the point of the policy, why a trial court administration might choose to implement this policy, do you see any benefit to that in terms of the overall public confidence in the judicial system?
I think that it has a negative impact on the public perception of justice. First of all, let's make it clear that this applies only to trial court employees and appeals court employees. All the other employees—
It doesn't. How does it apply to appeals court employees? The court administrator doesn't work on that.
The appeals court has adopted this rule. In the appendix, I've set out an email communication from the personnel administrator for the appeals court. The appeals court applies the trial court rules, but the SJC does not. The SJC's non-judicial employees are entitled to a discretionary decision on whether they're going to be suspended. If they're suspended with pay. But this is the statutes that deal with other state employees, that is, municipal employees and executive office employees, all have a discretionary element in them, either in the decision of whether to suspend the person or in the decision of whether or not the person will be paid. And the statutes also have, the statutes and not the SJC rule, but the statutes also have an exoneration provision. That is, when the criminal case is over, the employee is made whole if she is exonerated. Now that provision is not in Rule 16600B. So this is, in equal protection terms, this is the harshest and broadest statute, that it covers the widest range of conduct, and it permits no discretion. And it results in events like this, where Ms. Moore's status is completely outside the control of the trial court at this point. Once this rule is triggered by a prosecutor indicting an employee, the penalty is absolute. It goes into effect immediately. There's no discretion exercised. The duration of it depends on events completely outside the court administrator's control. There's no provision for adjusting things subject to changes in circumstances. For example, Ms. Moore's trial has been postponed indefinitely because of an interlocutory appeal in her federal case. The COVID-19 events make no difference to this situation. Nothing can change until the criminal case is over with. This is really a draconian penalty.
Okay, thank you. Do we have any other questions? Thank you
Yes,
so
thank
much,
you.
Attorney Thompson. Attorney Desai, please.
Thank you very much. May it please the court, my name is Denise Tsai on behalf of the Executive Office of Trial Court Administration. And the decision of the single justice in denying Ms. Moore's petition should be affirmed because he did not abuse his discretion or commit an error of law for 3 reasons. First, turning to the statutory authority here, the trial court acted well within the significant authority given to it under sections 8 to set employment standards and sections 9A to impose discipline, including suspension without pay, in promulgating this rule, which is consistent with how most state and public employees are treated when charged with a serious crime, which is suspension without pay here. My brothers focused on the language when necessary to ensure the proper administration of justice doesn't restrain the court administrator's authority here, but rather is a matter of timing and how to exercise and how he may choose to exercise that discretion. And this rule in section 16600B makes sense for a number of reasons. Foremost among
Explain your prior statement, counsel.
I'm sorry, I didn't hear that, Your Honor.
Can you explain your prior statement, counsel, that section 12 goes to the timing of the exercise of the discretion?
Just to clarify, Your Honor, the language of when necessary to ensure the proper administration of justice, that clause that's found in section 9A, we think that's the plain reading of that just demonstrates that, again, that's the legislature's vesting of discretion in the court administrator to decide in what circumstances to impose particular types of discipline. That's not, we don't think a fair reading of that suggests that that is restraining the court administrator's authority to impose discipline in any way.
Well, it clearly limits the ability of the court administrator to impose this sanction unless it's necessary for the administration of justice.
Yes, Your Honor. And in this situation, the court administrator and the trial court have determined that in situations where an employee of the trial court has been indicted for felonies, here those felonies include drug and money laundering offenses, as well as lying to federal officials, the best course of action there to safeguard the administration of justice, as well as to safeguard the integrity of the judicial system, is to impose suspension without pay. It's not just a matter of administrability and protecting the integrity of the judicial court system. Again, it does treat trial court employees consistently across the board with each other, and also treats them consistently with how most state and public employees are treated when facing this situation. It also provides clear notice to any trial court employee on day one, do not get indicted for a felony because this is the consequence that will arise. It's a clear message, and again, it would be unfair. This rule, as well as the other statutes relating to state and public employees, recognize that it would be unfair to taxpayers to have to pay the salary of someone who's been indicted for a crime while their criminal process is still ongoing.
Whether it's fair or not fair, the issue that we need to start with before we get to the rule is the statutory interpretation of 9A12. And doesn't the language suggest when necessary to the proper administration of justice and may, and having an option including dismissal and suspension with or without pay? I mean, I understand your statutory interpretation, but doesn't the appellant statutory interpretation make more sense that that statute is speaking to the exercise of discretion on a case-by-case basis, not discretion before events occurred?
I don't think so, Your Honor. I think a fair reading of the statute allows for the court administrator to determine in the first instance what types of discipline are appropriate in what circumstances, and to set forth this bright line rule. And I think this court in Campitelli does recognize that significant authority has been vested by the legislature here in the court administrator's ability to render discipline among its own employees. And if Your Honor has no further questions about that, I'd like to turn briefly to the equal protection argument that my brother has raised. As the single justice concluded here, Joseph doesn't call for a different result with Ms. Moore's suspension without pay decision. All three opinions in the Joseph decision recognize that as a baseline rule, trial court employees are bound by this Rule 16600B. Judge Joseph, who is a sitting judge, is not an employee of the trial court and therefore isn't bound by that manual. And beyond this baseline rule, there were very special concerns there that both the plurality concurrence and the concurring opinion both found that resulted in a different treatment for Judge Joseph. And none of those concerns expressed in those opinions is present here. There is no threat to judicial independence or separation of powers. The indictment for Ms. Moore's did not flow from a decision she made on the bench. And with respect to the ability to seek other employment, she's not bound, as a judge is, to the same restrictions on what she can do. For example,
do you agree, counsel, that if we had adopted Judge Gaziano's perspective on Judge Joseph, that we would have a different argument here? Or do you think that we would be in the same place?
Your Honor, I think if we adopted Judge Gaziano's perspective from the Joseph decision, that would really underscore why there is not an equal protection issue here. I think the concern there was treating a judge differently from a trial court employee, understanding that the rule applied to all trial court employees is mandatory unpaid suspension in this situation. And I believe in the Judge Joseph's case, there was a court officer who was subject to the rule, just as the petitioner is. And so I think that just demonstrates that, again, there were a very unique set of extraordinary circumstances there under which this court used its inherent judicial authority to treat Judge Joseph differently. But the normal baseline rule and the rule that was applied to the petitioner is the one that is found in the trial court manual. And I'd like to just...
Sorry, what about the treatment of SJC employees? What is the rational basis for treating SJC employees different than trial court employees?
Yes, so just to correct something that my brother mentioned, I believe he said that SJC employees, if indicted for felonies, would not be suspended without pay. I think the rule does still allow discretion there, and I'm not aware of any instance where an SJC employee who is under the same circumstances here received paid suspension. But regardless, one difference is that the trial court has over 6,000 employees across around 100 courthouses in the Commonwealth. And the court administrator determined one reason for this policy is that its resources shouldn't be used to conduct case-by-case adjudications of an appropriate disciplinary action when an employee has been indicted for a felony. I believe the SJC has a far fewer number of employees. And of course, the two are separate employers. And again, most state and public employees, leaving aside those who work for the SJC, would be treated the same as Ms. Moore under Rule 16600B. I'd like to add that just its administrability here isn't just a matter of numbers, of course. I think the rule avoids a lot of dilemmas that could arise from conducting a parallel employment investigation while someone's criminal investigation is still ongoing. For example, there's a lack of evidence when there's been a grand jury indictment It respects a defendant's Fifth Amendment rights in their own criminal proceeding. It avoids prejudicing their criminal defense. For example, if it would seek to put an employee in a very difficult situation of prematurely airing evidence or their own criminal defense prior to doing so in their criminal case. And it respects the criminal justice system and allows it to play out. And there's a measure of finality as well, only in the sense that petitioner essentially is seeking the trial court administration to take notice of every single development that's been happening in the criminal matter, including motions to suppress evidence. I don't think it's reasonable or practicable for the trial court administration to follow every single step or every development in the criminal case in deciding at what point is discipline and what type of discipline is appropriate. And so in that respect—
Counsel, how are these administrative benefits, given the size of the trial court, consistent with the requirement to give due process to the individual employee? That is, you're describing a pro forma hearing that she apparently got, where the outcome was predetermined by a bright line rule established by the court administrator without regard to her particular circumstance. How is that consistent with a due process hearing?
Well, Your Honor, Ms. Moore here did receive notice of the action, the decision of unpaid suspension, and upon requesting her opportunity for a hearing, was given that hearing promptly, at which she was able to present any evidence or arguments. But
I guess that's my point. Given the benefits you're describing, the administrative benefits, the impossibility of keeping track of what happens to Mrs. Moore's federal case as it continues, how was the hearing that she got consistent with due process if the outcome was predetermined by this bright line rule?
I think, Your Honor, that Perillo helps answer that question because it sets forth the idea that procedural due process derives from a source. And here, under the statutory authority vested in it, and under Rule 16600B, the court administrator has set forth a process in its manual for a notice and a hearing. And in Perillo, that opportunity for a notice and a hearing satisfied procedural due process. Here, factually, Ms. Moore also received, even beyond what was provided in the manual, she received 2 opportunities for reconsideration or appeal after her counsel presented additional evidence and arguments.
You're saying Perillo was the case where the outcome was predetermined and we said that satisfied due process?
No, Your Honor. In Perillo, this court looked at the procedures provided in the manual and recognizing that there was no divergence from that process, as well as recognizing that there was a full and fair opportunity for a hearing there, found that satisfied procedural due process. And just to address Your Honor's earlier question of was this a pro forma hearing, we don't think it was, because there are ways that, not present here, but there are opportunities for an employee to present information that could overturn the decision. For example, if they provided evidence that they weren't charged with a felony or actually charged with a misdemeanor, a different section of the manual would apply in that situation. And although it's likely not a very common occurrence, it is one that could happen where someone would present evidence that they themselves were not actually the person who was charged, who was indicted for a felony here. Again, it might seem a bit far-fetched, but our office has 2 recent cases where people who have dealt with issues of mistaken or stolen identity in encounters with law enforcement. One person was arrested with a stolen ID, and so it took months for them to determine who that person actually was. In another case, someone had the same name and birth date as someone who I believe was supposed to be on the sex offender registry, but it was not actually the person who at issue. And so in as much as Ms. Moore herself admitted that she had been the one who had been indicted for felonies, she could not overturn the decision, the unpaid suspension decision mandated by the rule. But the hearing process does allow for some possibility there of presenting some evidence so that the rule would not be the one applied.
Everybody all set? Okay, thank you very much, counsel.
Thank you.